I meant to say at the beginning, same disclaimer as Commissioner Wilson's, that these views are my own. I will just say for my own self, I think many of these anxieties are overblown. The first point I would just like to make is to remind ourselves that none of these challenges are unique. Every agency with rulemaking authority has to decide whether and when it's appropriate. Many of the agencies also have enforcement powers and make choices about rulemaking versus one-off litigation, case-by-case litigation. This is a highly routine, unremarkable feature of the administrative state, and the FTC is no less capable of making these appropriate judgments than any other agency given such authorities. If anything, there are ways in which the FTC is especially well-suited to make rules. APA rulemaking already creates significant opportunity for public participation to ensure an agency makes well-considered policy decisions. Magnuson-Moss rulemaking, as we heard this morning, creates additional procedures to ensure participation. Moreover, the FTC was created to be an expert body with both law enforcers and economists who can bring their expertise to bear on the questions at hand. We also have unique study tools, like our 6B market study tool, as we heard this morning, as well as steeped traditions like our workshops and open comment dockets to intake a wide breadth of information about a topic on which we are considering making policy. We are an excellent institution to consider all angles of a problem and to think about whether and when rules may be appropriate. Second, I want to address the idea that rulemaking requires significant resources to accomplish. And again, as we heard, and I won't deny, sometimes in particular with Magnuson-Moss, the resources and the time can be significant. First of all, it's true, as I said, that a rule might be a big upfront investment, though that's not always the case, depending on the scope of the issues and the degree to which the project is planned. We heard again this morning about the very good article about the history of our rulemaking from Tim Uris and Howard Beals. And I don't disagree that a lot of rulemaking is really honest to goodness, hard, unsexy project management and prioritization. And a lot can be achieved by focusing there. And as I've already said, rules can create efficiencies vis-a-vis enforcement. But even when rules are particularly costly to make, they can be well worth the time when they have significantly salutary effects on the market and market participants, potentially over decades. I'm just going to take two examples of early rules that were controversial when they were passed by the FTC, but that have stood the test of time protecting consumers over generations, with significantly less resources from the FTC to enforce consumer rights. First, the very excitingly named holder in due course rule, which FTC lovers may have heard of, but others may not have. This was designed, speaking of wonkiness, to allow consumers to assert defenses against third-party creditors that they could have asserted against the original seller. So the problem was you have fly-by-night fraudsters who sell bad goods. They take payment on credit. They sell that credit note to a third party. That third party can enforce that credit note even though the goods were fraudulent. Rampant problem taken care of by a rule. That rule was promulgated nearly 50 years ago and has been called the FTC's most effective tool against fraud. It's a clear prohibition against a significant abuse, and it has paid for itself in spades. The same with the credit practices rule, which I spoke about before, which prohibited certain remedies in consumer contracts. It has successfully prevented some of the worst abuses in such contracts, so that many people have called for it to be expanded to other credit markets. It is around 40 years old and has been protecting consumers and the public at large ever since. Third, I want to address the idea of legal risk in rulemaking and in parallel, the idea of institutional risk. I have sensed a suggestion that taking on legal risk when we do rulemaking is somehow inappropriate. Certainly, as stewards of the agency, leadership has an obligation to protect the institution and its mission. But I would suggest that having a zero tolerance for risk would not be fulfilling our obligations to apply the creativity, nimbleness, and innovation necessary for this small agency to meet its significant task. More than that, some of the agency's greatest successes would never have been realized if the agency took a zero-risk approach. Take, for example, the telemarketing sales rule and its progeny, known colloquially and favorably as the do not call list. That list protects Americans from abusive telemarketing calls. That rule has been called possibly one of the most popular federal regulations in history, and it would never have come about if the agency hadn't been willing to risk the inevitable First Amendment challenge that it knew was coming. Indeed, in that case, the FTC lost in district court on First Amendment grounds, but fought on because the risk was worth the protection the FTC could provide against abusive tactics. Or take the eyeglass rule, which requires optometrists and ophthalmologists to provide patients a copy of their prescription after completion of an eye examination without extra cost. Think when you go to your eye doctor and then you take your prescription to Warby Parker and get a cheaper, or potentially, if you think, more fashionable pair of glasses, you can thank the FTC for that. Significant parts of that rule as originally written were struck down, and I think some feel that that is a black eye on the agency. But the popular provision that I have just mentioned survived arbitrary and capricious review and has spurred disclosure, competition, and innovation in the industry. In a win some, lose some game, you do lose some of the time. But that's okay. That's the back and forth between agencies and the courts that our system created. It shouldn't chill us from doing our best. If it did, we would be acceding to the equivalent of lose all, which would not be what we are here to do for the American people. Just as an aside, the eyeglass rule is also known as one that is required over the years very little enforcement. Just showing as another example the ways in which an early rule, it's fairly old now, can protect the public with an extraordinarily efficient use of resources. Last, I want to address the idea of democratic legitimacy. Should the FTC be making rules that could have a broad economic impact? I'd answer an emphatic yes. Where we make rules within our statutory ambit, as we are, the FTC is the right institution to be making both competition and consumer protection rules. Far from being lawless, using statutory tools that Congress gave us to make rules concerning the conduct Congress was concerned about is a fundamentally law-bound exercise. We are public servants, tasked with serving the public in the way Congress intended, using our best judgment and ingenuity to do it effectively. We have an obligation to use those tools to make the maximum impact we can in people's lives, and that's just what we are doing. Indeed, when we talk about legitimacy, my mind goes first to a very different place. It was a moment that stood out starkly to me in the first months of my time at the FTC. We conducted a series of listening forums with market participants about their experiences with mergers in various industries. We heard from small businesses, from entrepreneurs, from workers, from investors, and others who had firsthand economic experience with consolidation in their industry. At one point, one participant said to us that even our act of listening to them and to their experience had renewed their faith in government by showing that someone was trying to do something about real material problems in their lives. Many have highlighted the concerns about overreach. An unexamined problem may be the significant costs to inaction or neglect. When we ignore the mandate we've been given and the tools we've been given to fulfill it, we undermine our reason for being in the eyes of the public. We are bound by law. The wellspring of our authority is Congress. The creativity and ingenuity to do our jobs with excellence comes from our staff. And when we are doing it right, we fulfill our contract to the American people that government that they support will work for them. That, to my mind, is democratic legitimacy. Now, a last note on competition rulemaking specifically. One might say, yes, in general, rules can generate all the benefits I've described, deterrence, clarity, durable efficiencies, and the like, but how does that apply to competition rules? First, I'd say, again, the FTC is not unique. Many of these benefits apply equally as well to almost any subject matter. But there are some additional reasons of interest in the competition realm. Here, I'll start with the agency's recent policy statement regarding its unfair methods of competition authority, which provides important context for why and where competition rules may be appropriate. First, as the policy statement makes clear, Congress passed the FTC Act in 1914 against the backdrop of significant skepticism of the judge-made rule of reason approach. Congress was concerned about a potentially inconsistent and unpredictable approach to antitrust law. And indeed, antitrust has been especially singled out for the complexity, length, and expense of litigation. And again, this morning we heard about the desire, in fact, during the 1975 debates about amendments to our rulemaking authority, the desire to preserve our ability to give guidance to regulated parties in competition precisely for this reason. Antitrust is an area then that, then as now, cries out especially for added clarity that may be achieved through rulemaking. As an alternate to the judicially created rule of reason, Congress expected the FTC as an expert body to develop an understanding of various types of unfair methods of competition and develop a different, informed approach to protecting against them. As I said before, the FTC was especially created with tools to study markets, in part to be able to develop considered views as to what constituted an unfair method of competition. With these origins in mind, and relying on a close reading of the statutory text, the legislative intent, and the case law, our policy statement describes a framework for determining whether a practice constitutes an unfair method of competition. It also posits some conduct for which no pro-competitive justification can be found, as well as conduct for which there might be some very narrow justifications. Rulemaking based on significant evidence, experience, and the like can, where appropriate, help develop out what conduct constitutes an unfair method of competition. And rules, which can include prohibitions, presumptions, guidelines, and more, can provide an appropriately flexible avenue for dealing with complex market structures and effects in a clear and simple way. Now, what does appropriate mean in this context? When might a competition rule be well suited to meet a challenge? I think with respect to the non-compete rule that the FTC has proposed, there are a number of features that strongly suggest that a nationwide rule is appropriate. As we review in the proposal, there's a large body of evidence across industries and income levels about the effects of non-competes. That evidentiary record demonstrates significant harm to competitive conditions and to market participants. We preliminarily estimate a loss of $250 to $300 billion per year in wages to American workers, as well as impacts on innovation, business formation, and consumer prices. I'll add an important feature that the proposed rule finds effects in the aggregate, which is a unique feature of unfair methods of competition as an authority. Non-competes have been the subject of antitrust scrutiny for at least a century, but often on a case-by-case basis. What we find in the proposed rulemaking is that non-competes have effects on workers who are bound by unenforceable contracts, workers who are not bound by contracts, non-compete contracts at all, and of course consumers in an entirely different market. Which makes rulemaking an especially attractive potential avenue. The literature also strongly suggests that non-competes are coercive and exploitative as to large swaths of American workers, within the understanding expressed in Supreme Court case law about what unfair methods of competition are intended to reach. Not only is this legally relevant, but it also counsels in favor of action, as affected participants are unlikely to have or find avenues to enforce against non-competes through private means, making government intervention important for market discipline. Finally, a clear nationwide rule is appropriate where, given the important spillover effects at play. The evidence indicates that non-competes clauses suppress wages, as I said, even for workers who are not subject to non-competes, by preventing jobs that would be a better fit from opening up to those workers. Many labor markets cross state lines. For example, 4 of the largest metropolitan areas in the United States include more than one state. And finally, employers may seek to circumvent state restrictions through the use of choice of law provisions. So all of these things suggest that a nationwide rule, if we are to appropriately regulate markets, may be well appropriate. I'll close with this. The FTC has an enormous mandate given to us by Congress that goes right to the heart of protecting the economic liberty and autonomy that is central to the American project. Our agency's vision is, and I'll quote here, of a vibrant economy fueled by fair competition and an empowered, informed public. That's a grand vision, one that I know I want to be a part of and one that I know that our staff is extraordinarily excited to be a part of. We are a small agency, but we have passion, we have fidelity to mission, and we have the creativity to live up to that congressional mandate. In order to carry out our mission, we have to use all the tools in our toolbox, the toolbox Congress gave us. Rulemaking on both the consumer protection and competition side is an important tool that we cannot be afraid to use where it's the most effective one for achieving our mission. Thank you.
So Elizabeth has also generously offered to answer questions. Just a heads up, if it goes beyond what has already been in the NPRM, it becomes part of the rulemaking record. So for legal reasons, we're not going to go there. So there might be some questions where Elizabeth wants to just say, nope, we can't do that. And that's why. She's not being difficult, that's just how it works. And so thank you, and questions, what do people want to know? Yes.
Well, first, thank you, Elizabeth, for your comments. I thought they were very interesting, and I really appreciated you sharing them with us today. I have a question that is not at all about the specific rulemakings at all, so hopefully will not trigger the prohibition. But when you think about UNC rulemaking, I'd love to hear your thoughts on what you see as, or if you see, any potential downsides from the loss of rule of reason weighing benefits in sort of fact-specific circumstances of a given, whatever the conduct is, putting aside whether it's non-competes or anything else.
It's a good question. I think this is a little bit where I tried to talk about where we think rulemaking might be appropriate. Our policy statement gives, I think, a little bit of an inkling as to how we might think about this. Commissioner Wilson walked through the framework, so I didn't, but we talk about conduct that's sort of facially unfair, coercive, abusive, et cetera. And then we talk about conduct that might not be sort of facially unfair, but tends to negatively affect competitive conditions. You can sort of think of that, as we say in the policy statement, as a sliding scale. You can also imagine that in that sliding scale, the closer you get to, well, this isn't facially unfair, but it seems to have some significant impacts, the farther you get into, well, how do you weigh those impacts on whom and how? Versus this is something that is squarely within the wheelhouse of the type of conduct that we think Congress just meant to say, no, you can't do that, with less regard to what the effects might be. I can talk as long as I want to about what's already in the proposal. So in the non-compete proposal, we have a long explanation of what we believe to be coercive and exploitative about non-competes, which might suggest more and more, okay, these are circumstances where, as we say, we have proposed a bright line rule. We also talk about the tendency to negatively affect competitive conditions, and so we talk about trying to sort of cash out the effects, negative and positive. All of that is to say, stepping back, the more that conduct seems to fall within either one of two things, sort of highly oppressive, or whether it seems kind of like the, not so different from the per se rule analysis that courts used to more engage in, where we have enough evidence and experience to say this is the way this cashes out every single time, we don't have to keep doing it, the more that I think kind of bright line rules might be appropriate. That said, we have proposed a ban on non-competes, but in our kind of alternates, we talk about a lot of different alternates, including various types of presumptions, et cetera. So there may be a whole other swath of conduct where a rule might be appropriate, not to say that there shouldn't be some kind of balancing or some kind of back and forth, but we have enough kind of experience to say we can streamline what this looks like in this. We can reduce the administrative costs, we can reduce the burdens, we can be more effective at enforcing by creating a presumption that is specific to this area, because we have seen this so many times in this industry, in this whatever, that we can make it more thoughtful. And where we have less evidence, where we have less experience, where we don't yet know how that cashes out, then something more like rule of reason might continue to be appropriate.
All right, I saw another hand over here, I thought. Yes.
Aaron Soka, Tech Freedom, thank you again for speaking here to us today. Two questions, if I may. They are actually questions. So you noted a few times that many agencies have to deal with the trade-offs involved in rulemaking. You said that there's nothing unique about the FTC. You're in a room full of people who think that the FTC does have unique power, that the fairness power is really something quite extraordinary, and that it's simply not reasonable to think that the Congress in 1914 gave to a new agency, such as had never been created before, power to determine unfairness, which is really the most sort of legislative power one could possibly imagine, over nearly the entire economy, in an obscure provision statute that was accompanied with no enforcement power to punish violations of the rules. So many of us think that the FTC just couldn't possibly be thought to have rulemaking power, in part because the power at issue on fairness is such a vast, amorphous power. So I'm just curious to hear whatever you feel comfortable commenting on that question. And then the specific question is, for those of us who think the agency is likely to lose on the 6G question, we certainly might think that there might be a problem with some agreements. We hope that the agency is thinking about ways to take a belt and suspenders approach. And you said to use all the powers that it has. You noted that one of the most egregious examples of non-compete agreements being used is that they're often placed in jurisdictions where they're not lawful. And it's all to have it. I think it's quite reasonable to propose that that's a really good candidate for a deception rule to prohibit such non-compete agreements from being required in such states. What thoughts do you have about how the agency might proceed on a two-track basis to propose that kind of rule through the bag loss process, such that can be on a firm legal ground, even if the court does rule that 6G will support competition?
So as to your first question, which is essentially some of the arguments about whether we do in fact have the authority to make competition rules, a few things. Certainly unfairness is, we have unfairness on both sides. And certainly nobody is disputing that Congress gave us the power under Magnuson-Moss to make rules regarding UDAP unfairness. So certainly it's not out of the question that Congress thinks that we ought to make rules regarding unfairness. Everybody agrees that we have that power. And as to 6G, I think, a lot of the arguments have been made today, and we say in our proposal, 6G, the statute is clear, the language is clear. There are other parts of the statute that are clear and wouldn't make a lot of sense if 6G did not grant substantive rulemaking authority. So we think we're on firm legal ground here. If we are all textualists now, as we like to say, the text says we have the authority. And, ultimately, as I said, our obligation is to read our statutes, understand what we think our authority is, and understand how we think we ought to most effectively pursue our mission. Ultimately, courts will decide. We know we're going to court because we've been told so. And
Tom Merrill said you were too.
oh, right. So right. It must be true. So we'll see. But as I said, my attitude there is that's the way that the system was set up to work, and our job is to pursue our mission. As to belt and suspenders, we have announced 3 consents under unfair methods of competition against companies who are employing non-competes under the same theory that the rule uses. So certainly we have already demonstrated our willingness to use more than one tool to think about this issue. One thing I'd point out in the NPRM, in our discussion of why we believe these to be coercive and exploitative, is this isn't just an information asymmetry, it's also a power asymmetry. And disclosure rules can be extraordinarily effective in certain circumstances. This is a place where we think something more than a disclosure remedy is appropriate to empower workers to get the market effects that we are looking to achieve.
Yes.
My Mark's with MLAs. Question for you. In light of the Supreme Court decision last year in West Virginia versus EPA, how is that factoring into your rulemaking and other deliberations? They seem fairly explicit that if Congress doesn't say you specifically have the power, it just means you can't do it.
So I'm not going to talk extensively about our legal deliberations, but I'll point out a couple of features of the rulemaking. As we say, the regulation of labor markets in general, of vertical restraints more specifically, and of non-competes very specifically has been the subject of antitrust scrutiny for at least 100 years. This is not a new or surprising area of regulation for a competition agency. And it is one that we have competence in. As folks have been discussing today, it's also not a new or surprising rulemaking authority. We've been thinking about it for at least 50 years, and if you think about the trade regulations that the agency has done for a very long time. So I think you can look to our proposal itself for the evidence that we have a clear statutory grant of authority, that this is a clear subject, appropriate subject for antitrust scrutiny, and that we have competence here.
Jeff.
Hi, Jeff Lovers. This is a nuts and bolts questions. We've got about 13,000 comments already, maybe a week ago or something like that, so you're going to get a lot of comments. How are you organizing yourself to deal with those comments? You have to get outside help? Can you do it with your staff? And how long do you think it's going to take to do it?
So this is like a nuts and bolts question, boring answer. When Aaron introduced me and he sort of chuckled and said, I guess Elizabeth is good at being a chief of staff. And when I said, this is not very sexy, but a lot of whether an agency is good at rulemaking comes down to basic, it's not anything fancy, it comes down to basic project management. Do you scope the problem at hand? Do you appreciate the resources that you need, et cetera? So without going into great detail, I will say, we have a very detailed staffing plan based on major rules done by other agencies. We have expertise on the team of people who have gone through major rulemakings with more than 1 million comments, so we understand what, not to say that we think we're going to have 1 million comments, but to say we have people who understand what it means to put together a team that has to get through those kinds of comments. I'm not going to kind of tie us to a timeline. I will say I mean, what I will say is it's incredibly important that we take seriously examining the comment record. Not just because of the, APA requirements, but because we recognize that regulation is a pretty serious authority, and we want to take seriously what we review. And we've been talking lots and lots about our proposal, but the whole point of having a comment record is that our final rule is based on the additional evidence and perspectives that we get in the comment record. So, the comment period closes on March 20th. I hope nobody is expecting us to come out with a final rule within a couple months of when that happens. There will be a significant review period. And then for all of us here who are FTC aficionados, that the commission doesn't just approve a proposal the day after it's forwarded to the commission. Commissioners are pretty hands-on. So it'll take us a little bit. But I have high confidence that we've put together a team and a project management process that can handle this.